Good morning. Probably as no surprise, we only have one case on the docket. And Mr. McCabe, you ready to proceed?
Sir. May it please the Court, my name is Bill McCabe. I represent the claimant Reinaldo Garcia, and I'll reserve 2 minutes for rebuttal. In this case, the Judge of Compensation Claims denied claimant's claim for permanent total disability benefits from December 12, 2006. We submit the judge has erred for a number of reasons. First, we submit the judge erred as a matter of law in relying on the vocational opinion of Mr. Lopez to deny claimant's claim for permanent total disability because it violates the law of the case.
Well, can I ask you a question about that? I mean, let's assume that we take Mr. Lopez and we just throw him out. He doesn't exist. Doesn't this case really turn on the JCC finding Mr. Roberts' testimony persuasive?
Well, the judge...
I mean, doesn't she have to accept Mr. Roberts and basically his premise that your client is PTD?
Well, yes. I mean, the claimant has to present evidence that the claimant is permanently totally disabled.
And she would have to accept it.
But the thing is that she didn't... this discussion came up at the last oral argument, too. But she really doesn't reject his testimony. She says, I accept the opinion of Mr. Lopez over that of Mr. Roberts where they may differ.
But, I mean, but for instance, she does go into some specifics, and frequently I think that, or at least it was always my theory when I was practicing, that credibility is built on the little things. In other words, you walk into a courtroom, someone identifies the litigants to you, and with no familiarity with the case at all, you'll probably know instinctively what their big points will be. But so the credibility is built in what they say on the little things. And so when I went through the record, Mr. Roberts, I think that she felt that Mr. Roberts overstated the extent of the limitation on the left non-dominant arm. I think that she thought that Mr. Roberts put too much emphasis on the fact that the individual was Spanish-speaking. I guess what they really meant was not that he was Spanish-speaking. That would be an enhancement. The fact that he wasn't very fluent with English is probably what they meant to say. But if and it's a non-dominant arm, and so if she finds problems with these little things, like no movement of the left arm, and then the FCE says he has some impairment of movement, but he certainly has movement, doesn't that give her reason to say, I'm just not comfortable saying that this 49-year-old man is totally and permanently disabled because he has a left shoulder non-dominant injury?
Well, the reasons that she gives, even for accepting Mr. Lopez over Mr. Roberts, really aren't supported in the record. For example, she accepted Mr. Lopez over Mr. Roberts because of on the question of the existence of transferable skills. Well, they had the same opinion on transferable skills. Claimant has no transferable skills into the sedentary work capacity. So that's not a very valid reason. As far as she did comment on Mr. Roberts' opinion about Spanish speaking, he thought it was to claimant's detriment in getting a job, even though I know he lives in the Hialeah area and there's a lot of Spanish speaking people.
But he worked for 49 years.
Yeah, but the thing is, too, the job he had, I mean, yes, he was working when he was there, but he had the last job that he got injured on for 16 years. So it's not like he was going out testing the labor market all the time. Plus, out of the 10 jobs that Mr. Lopez found in his labor market survey, none of which claimant could do if you consider the vocational, educational, and other factors, 4 of them required English speaking. So there's a 40% of the jobs that Mr. Lopez said he found that not being able to speak English is a detriment.
Well, I guess my point was really that obviously I don't think that our case law suggests that the JCC must choose one of these witnesses and accept their testimony, and I think that with the person who has the burden of proof, if they fail to convince the JCC, then that issue is decided against them, even if the other side forgets to show up at the hearing. I mean.
But the JCC can't abuse her discretion and just willy-nilly reject testimony that's presented to her, I mean, without some sort of valid reason, particularly if it would be unrefuted, which Mr. Roberts' testimony would be in this case, if you take the position that the court actually took in the first order, that Mr. Lopez's testimony is not competent upon which to support a denial of permanent total disability. The judge in this order, the court noted it in the last opinion, in this order, the judge still makes no finding of any particular job that this claimant can do. She just, again, conclusory, comes to the conclusion that there is sedentary work that he can perform, even though there's no specific job anyone can point to, once you take into consideration all the factors that he can do. And this is also one of those situations where the employer carrier waits until 2 days before the final hearing to do this labor market survey to come up with these purported jobs that this claimant can do. I mean, I'd submit that's not how the Workers' Comp Act is supposed to work. But I understand what you're saying, but my answer to that is, on this record, the judge, well, I'll say she abused her discretion if she's just flat rejecting Mr. Roberts' opinion. He bases his opinion on the fact that the claimant was restricted to sedentary work, which is what the judge found. The judge said, I accept Dr. Hoder's opinion that the claimant can do sedentary work. And Mr. Roberts pointed out the fact that whatever jobs claimant could purportedly do, he can't, according to Mr. Lopez, when you consider the vocational and educational factors. And so I would submit that based on the evidence presented in this case, the judge abused her discretion in rejecting Mr. Roberts, if we get down to that. And I cited the Allen Protel case where this court had a thing come up twice before it. The first time it remanded it back to the judge. And then the second time it came before the court said.
Well, Mitchell versus XL Communication, we remanded that, what, 3 times?
I know you have some cases keep coming back. But anyway, I think I'll just reserve the rest of my time for rebuttal. Thank you.
Your Honor, it's John Darren appearing on behalf of the appellees. With regard to the essence of this case, I think it boils down to feral gas versus Childers, in which this honorable court stated that in reading the 2003 amendment to Florida Statute 440.15 dealing with permanent total disability, the court should look beyond the plain language of that statute, which talks about sedentary labor within 50 miles of the home, and go back to the old 1994 case law that talks about vocational history, vocational factors. And I would ask that this honorable court either recede from feral, because I think 440.15 is pretty specific and doesn't need interpretation. I think it's sort of like looking at the case of slavery in the United States, where it gets abolished. And it's if the court says, well, we did have some cases that dealt with property rights for slave owners before slavery got abolished, and those look to be good cases, so we'll use them now that slavery has been abolished.
Well, wasn't the statutory changes? I mean, I thought that the panel in feral gas basically said the statutory language is almost identical. I mean, it's 50 miles instead of 100 miles, so the legislature would be, I guess that could be interpreted as a little more generous to claimants, and some other slight language changes, but in essence it was the same statute. I mean, because they had left that, tried to go to the Social Security thing, which I don't think worked out the way the legislature thought it would. And
that's exactly my point, Judge Hawks, is that they went to the Social Security test, which incorporated the vocational, the age, the lack of language, lack of English language, pardon me. But they did embrace all those things that were in the earlier court decisions, and then they rejected it in 2003. They said, you know, there are far too many people that are not going to qualify for permanent total disability under the comp statute, and this is not what we intended. And I would either ask the court to either recede from feral gas versus Childers, or in the alternative, and I'm going the opposite way here, expand upon it. If this honorable court feels that vocational factors need to be considered, like in this case, maybe give us a little bit more inkling of what vocational factors the court would like to see considered?
Well, I mean,
are you talking about just vocational history, or are you talking about functional, transferable skills? Are you talking about trainable skills? What is it we're looking at when we're talking about vocational
The statute
factors?
already gives you some burden, right? I mean, when Mr. McCabe says that you waited till just a few days before the hearing to do a job search, or, you know, I mean, really, wasn't that something that was supposed to take place a long time before? I mean, and really, it wasn't supposed to be just preparatory for hearing. I mean, it was really supposed to be helping the claimant find a job, wasn't it?
If we go along that line of thought, Judge Hawks, then shouldn't, you know, the burden of proof is on the claimant. Shouldn't the claimant have made even one job search? This fellow testified at hearing he never looked for work anywhere. And so, you know, the burden of proof is on the claimant before the JCC. And, of course, as a backup measure, as a matter of strategy, you don't want to go out and get a vocational job market survey too long before the hearing. You're just asking for the other side to find fault with it, like they did in this case.
I guess what I was thinking is perhaps not just this trial strategy, but you know, basically you have this claimant who has reached maximum medical improvement. He has some impairment, and so then the employer carrier comes along even before, perhaps,
and as I pointed out
before he gets an attorney, and they say, let's see what we can do to find you a job.
And as I pointed out in my brief, Judge, you know, you've got people that are probably in wheelchairs that can do marathons, they can climb mountains, you see them on TV. You've got some people like this claimant who's applied for Social Security disability, he's applied for permanent total. Some people just aren't motivated. And as long as this
Counsel, your example, if we take the number of motivated people in wheelchairs and determine which one of them can climb mountains, I think you're talking about like 1 out of 100,000 or 1 million. That example I found offensive. And so it seems to me the panel in the first Garcia case criticized the employer carrier for not using the reemployment and rehabilitation provisions. And in your brief, you say, well, the reason we don't do that is it'll be sabotaged. And that doesn't seem to be an adequate answer, because it seems to me if that's the case, then that can be proven. So I'm struggling, like I think maybe Judge Hawks is why doesn't the employer carrier be a tad more proactive?
I think it's because, I'll be honest, for starters, I think it's because they're afraid that in a permanent total case, there's simply going to be sabotage. But let's go beyond that for a second, Judge. In this particular case, there's no issue about rehabilitation. The other side didn't ask for rehabilitation. The other side didn't ask for retraining. It might be a great case on appeal if those things had been claimed or requested under 44049, which authorizes rehabilitation and retraining. But we're not here on a rehabilitation or retraining case. We're here on a permanent total case where the fellow never even did a job search. And so I think it's a red herring, because that wasn't even an issue in the lower court. You know, you can complain now about, oh, they should have retrained, they should have done more of a labor market survey, they should have done this, they should have done that. But basically, they didn't seek those benefits either. And so, Your Honors, with regard to the abuse of discretion, I think there's enough in the record for the judge to have gone either way on this one, either with vocational expert Lopez or vocational expert Roberts. There's enough in the record to go either way. And so I think if the judge does have the discretion to accept what testimony she wants to, and I don't think that her decision was based strictly on the vocational experts. I think it may have gone beyond that to the visual appearance of the claimant, to what he had done in terms of looking for work, in terms of what his real limitations were. And there may have been more to the case and more to her decision than just the vocational experts.
Counsel, let me go back to this reemployment rehabilitation. Do you read the statute as placing the burden on the employee to seek those as benefits, or to place the burden on the employer carrier?
It's been my experience that the employee will usually seek retraining because it entitles him to an additional 52 weeks of benefits, 26 to 52 weeks of temporary benefits, while he's going to a retraining program. And in a place like Hialeah, where this gentleman was, there are probably Spanish vocational schools, technical schools that he probably could have applied to, and he probably could have collected an extra 52 weeks of benefits. And there was no effort made to do that. And I don't.
But the statute clearly places a burden on the employer to determine the reemployment status at 90-day intervals. Then the carrier is encouraged to obtain a reemployment assessment. So it seems to me, even if you have an employee who is not taking any action on his or her own behalf, that the statute places burdens on the carrier, which, as our panel in the first Garcia case noted, hasn't been done here.
That's absolutely true. But is that dicta, Your Honor? Because basically that has nothing to do with the issues being addressed in this particular case. There was no claim for rehab or retraining. We're here on whether or not the judge should believe one vocational expert over another and whether or not the judge made the right decision. So when that case comes up, you're right. The employer carrier has the right to ask for an evaluation. They have the right to seek retraining. Claimant also has the right to seek an assessment or to seek retraining. But as a practical matter, a lot of these folks that get injured, they're looking for the lottery ticket. They want to hit the PT claim, and they're not that interested in retraining, Judge. I don't have anything further unless there are any questions of the court.
Thank you.
Well, I just have a few comments. First of all, as far as receding from Farrell, I mean, as you pointed out, the statute's identical to the pre-94 statute, except it says 50 instead of 100, and then it also has the word sedentary in it instead of light, but the court interpreted the light in the pre-1194 statute to mean sedentary work anyway. So the statutes are the same, and as far as I believe that it's the same way to prove PTD after 10-103 as it was prior to January 1st, 94.
Well, we really wouldn't have the authority to overrule Farrell Gas anyway.
Right.
I mean, that would have to go in bank. But
I know, because it would have to be in bank and all that. But now, as far as vocational factors and whatever, I mean, it's pretty clear. I mean, consider vocational factors such as a person ever worked in that type of work before, like some of the jobs were telemarketing or whatever for this claim. He's never done any of that kind of work before. Do you need to speak English? Do you need to be bilingual? Physical requirements are pretty obvious. Educational requirements, do you need some kind of a license like security guard?
it would be very fair to say that this is a factually intensive inquiry by the JCC where they have to look at the totality of circumstances. And one individual could have an injury and be rendered PTD. Another individual could have the same injury and not be PTD because of all these factual specific these specific factual inquiries that the JCC must make or the parties must bring before the JCC, right?
Yes, I would agree with that. I would agree with that. Also, as far as providing vocational training for a claimant, I mean, the intent of the statute, according to the legislature, 440-15, one of the intents is to try to return these injured workers to gainful employment. Well, how do you do that? You do that by, if you're employer carrier, by being proactive. And when a claimant files a claim for permanent total disability benefits, you don't wait for 18 months before you decide to send a vocational counselor to him.
Well, I mean, of course, if we take the other side of that, I mean, realistically, if your client thinks he's PTD, there is no ability for these other, I could argue, okay, if he is PTD, they made the correct call in not providing any of these other benefits. But you could have filed a petition for benefits and received that kind of stuff and received an attorney's fee for it, correct? I mean,
well, a claimant can ask for it.
I mean, every time a petition for benefits is filed, in essence, what the claimant's attorney is saying, or what the claimant is saying if they represent themselves, is I have a right under the statute for a benefit that's not being provided to me. And it's a benefit that realistically the employer carrier was supposed to pay or provide without the necessity of a petition for benefits, right?
Yes, but it's also supposed to be a self-executing system. And if a claimant files a claim for PTD benefits, one would think an employer carrier would look at it and go, well, let's do a reasonable investigation now, not 18 months later, to see if this claimant is in fact permanently totally disabled or if there is some retraining that this claimant can undertake. So
I take it that, in your view, the fact that the claimant never conducted any kind of job search or asked for retraining or made any effort at his own rehabilitation, is that legally irrelevant?
I'm not saying that it's irrelevant, Your Honor. And in fact, I think that one of the ways that you can prove entitlement to PTD is by doing a good faith job search, just as it was pre-1194, but it's not a requirement. And I would say this judge's order in this case, I guess I'm over my time, so I'll, if I can just finish with one comment. The court said in the prior order the judge made no finding as to what, if any, employment claimant could reasonably do given his particular circumstances and physical restrictions, and I would say the same is true with this order. Thank you.
Thank you. The court will stand adjourned. Thank you, gentlemen.